Live from the rooftop of the Hermann London Real Estate Group in beautiful downtown Maplewood, it's the St. Louis Realtor Podcast with your host, Adam Kruse.
Welcome everybody to the Hermann London Real Estate Group Podcast number 26. This is the St. Louis Realtor Podcast live from the rooftop in beautiful downtown Maplewood, Missouri. Today is June 28th, 2016, and we are excited because we have some very special guests. You'll see that today's topic is all about commercial real estate leases. So we brought in our commercial specialist from our office here, Matthew Simon. Some of you have heard him and met him before, heard the legend at least. And then also we brought in our company attorney, Doug Hickel. Doug, why don't you do your attorney disclosure, and then I'll kind of go into introducing you and all this kind of stuff.
Sounds good, Adam. Thank you for having me. I got to be a lawyer for a minute before I get started and let everybody know that I am not your lawyer, at least not right now, and that anything I say is just general legal thoughts and ideas and shouldn't be used as legal advice in your specific issue. So if you have a specific issue, call a lawyer.
And can I say call you?
You can call me.
As long as, you're not too busy with my legal stuff, right?
Correct.
Okay.
Or if you're mad at Adam, don't call me.
Okay, exactly. That's right. So what I want to do first is I just want to give kind of a quick intro, basically, to how I sort of met you and heard about you. You work at the Summers Compton. Is it Summer Compton's Wells? You guys still kept the Wells on there?
Yes, we still keep it on there.
Did you get rid of the hamburger? Is that right?
We did get rid of the hamburger.
Okay,
it's now
so
Summers Compton Wells.
So you're a partner there, and a family friend of mine is a partner there. And I remember as I was getting into real estate, his name is Dick, right? He would always be talking about the deals they do and all this kind of stuff and the leases that they do. And there's this movie, have you seen it, called Intolerable Cruelty? It's with George Clooney and Catherine Zeta-Jones.
I've seen it.
It's all about divorces and prenups, right? And they talk all about the Massey prenup, and it's unbreakable, and it's all this stuff. And so I always kind of compared the Summers Compton commercial lease to be this like strong lease, right? This like Massey prenup style lease. And when we got our office here, my landlord sent me over the lease for me to sign, and I'm like, absolutely no problem. I'm going to send it to my guys at Summers Compton, and this is going to be great. They're going to represent me. Everything's going to be fine. So I sent it over to Doug, and he calls me back about 10 minutes later. He's like, well, the bad news is we made this lease. So you guys made the lease, but ended up he referred me to another attorney who now actually works with you guys, right? But
yeah.
So it's you can't represent both sides on a lease agreement?
Unfortunately, no. We call that we have that as a conflict of interest.
Yeah.
We always want to be able to advocate for our client as best as possible, and riding both sides is tough for lawyers.
Okay, so just a little bit of getting to know you. I already said this a couple times, but your name is Doug Hickel.
Correct.
Or Douglas.
I go by Doug, but I am Douglas.
Okay, and you work at Summers Compton Wells.
I do.
How did you decide to be an attorney?
I come from a family of lawyers. My father's a lawyer. My older brother's a lawyer. So it was a natural thing for me to go to law school.
Oh, wow. Okay. Are they in St. Louis, too?
They both practice law here in St. Louis. My brother is an in-house attorney at a local company.
Okay.
And my father is a solo practitioner, does a lot of estate planning work.
Okay, so when you decided to be an attorney, you had to decide: do I want to be an in-house attorney, or what are you called?
Typically, there's three big categories. There's an in-house attorney, which works for one company only and is on their payroll, and then there's a second large category, which has two subcategories: is working at a law firm. And there you're either what I call a transactional lawyer, which is you help people buy and sell things, you help people lease things, you help people borrow money, all that type of stuff. And then the other side is you're a litigator. Then you go to court and you fight with people. So, those are kind of the three big categories.
So do you litigate?
I do not litigate, but I have partners who litigate.
So they would litigate and fight to say that the stuff that you wrote or the agreements that you made are strong or right or
typically
whatever.
People don't want to litigate after I write something because they know they're going to lose.
Right.
But if that situation ever does come up, they will litigate whether it's something I drafted or just another issue that the client has.
You as an attorney, are you kind of at your desk in your office most of the time?
I sit at my desk most of the day. I spend a lot of time on the phone with clients, talking to them, just because I have found that talking on the phone is better than emailing, because I can really get a better understanding of what issues they're facing and then be able to talk through it with them. And another term for a lawyer is a counselor at law. And as a transactional lawyer, you really do spend a lot of time counseling with your clients, helping them figure out the best solution to the questions or the issues that they're facing.
And do you specifically do real estate, or do you do other types of law?
Primarily I do a lot of real estate, whether that's buying or selling property, whether that's developing, helping people develop property, leasing property, financing property. Then I also have a part of my practice is mergers and acquisitions, which is a fancy way of saying I help people buy and sell businesses.
Okay.
And again, same types of matters there, helping them buy and sell it, helping them finance it, helping them through all of the issues that go along with owning your own business that you know so well, Adam.
Who is your target client? Who do you hope would be listening to today and say, I want to call this guy and hire him?
My favorite type of clients are small and medium-sized business owners who need someone to come alongside of them and be a part of their core team who helps advise them and helps them run their companies successfully. And be able to help them through the legal issues they have and some of the business issues, because oftentimes issues are not all legal or all business. There's kind of a mix of in between, and being able to be available to them whenever they need it, whether it's via phone or email or however, to answer their questions and help them with what they need. So a small, medium-sized business owner, similar to Hermann London. Other real estate companies, well, they're not as good as Hermann London. I would talk to them.
That's on record. I like this.
people who own real estate, who need help leasing it or want to buy some real estate, or just have general legal questions about their business.
Today we're going to focus on talking about commercial leases. I know you've done a lot of them, and you wrote our lease, and then you've helped us with other leases that we've done as deals. Basically, we brought Matt Simon in. He does a lot of leases and commercial stuff. I'm going to kind of play the role of, because basically we have a lot of different type of listeners, beginners. I've got Aunt Marzi listening. We've got random other real estate people across the country and whatever. So I'm going to probably ask more simple type of questions. Matt might have more complicated type of questions.
Yeah, I'll come with some follow-ups that may have affected me personally.
Sounds good. Try to get some free legal advice.
Absolutely.
I see how
Anytime
it
I
is.
get a
That's
chance,
why I'm here.
Those 15-minute billable hours,
Yeah, so if we're going to talk about commercial leases, let me start with something simple. There's different types of leases, obviously. There's leases more where the landlord has the burden, and there's leases more where the tenant has the burden. Can you talk a little, just briefly, about the different types of leases?
So, just to start with, a lease is a situation where someone else owns a piece of real estate and you want to use it. So you sign a lease with them that gives you permission to use their property, and sometimes that permission can be very limited. You're leasing a small kiosk for a very short period of time, like around the holidays. Or it could be an extremely long-term lease where you are leasing a piece of land and you're going to lease it for 99 years and you're going to have sole possession of it and do whatever you want with it, whether it's build a building on it or just sit there in your beach chair for 99 years. You can do what you want. So those leases then run the spectrum of who has the right to do what, who gets to control what decisions, and who has the obligation to pay certain things. A very common thing is who pays for the maintenance of a building, who pays to replace the roof, who pays to fix the air conditioner, who pays to
the taxes,
the real estate taxes. And those are all, there's no hard and fast rule about it. All of it is negotiable. People oftentimes refer to what is called a triple net lease, or then they try to call it a modified triple net, which may be a double net or a single net lease. And what the net means is that it's money to the landlord, net of taxes, insurance, and maintenance, which means the tenant pays to the landlord a sum of money, and the tenant pays all of the taxes, all of the insurance, and all of the maintenance in the building. So that would be what I would call a very landlord-friendly transaction, because the landlord gets a check in the mail and doesn't have to do anything.
They don't have to worry about if the insurance is going up or the taxes are going up or anything like that?
No, the tenant accepts that entire responsibility.
In what kind of situations are you seeing that? Would that just be if it's a more popular property, or is it on more certain types of leases?
It's usually on certain types of leases where a tenant is leasing the entire land and all of the buildings on it. So it would be as if you had a warehouse and somebody was going to lease the entire warehouse and all of the parking lot and all of the grass and everything that was there. That's a common situation that's triple net, where there's one tenant who's in control of everything.
Okay, I see Simon perked up over there because I know you're working on warehouse leases and stuff like that right now, right? So
yeah, and absolutely, the triple net is the most desirable lease out there for the property owner, not so much for the tenant.
And the reason for that is that the tenant, as you mentioned, Adam, absorbs the risk. They have the risk of, are the real estate taxes going to go up? Is the insurance rate going to go up? Is the roof going to need to be replaced?
Is that more like bigger business type of stuff? I mean, if somebody renting a little storefront doesn't want to have all that burden, right?
No, you wouldn't. And that's where a storefront differs from a warehouse, because a storefront is usually a part of a shopping center. Mm-hmm. So then you have an issue of space is going to be shared amongst tenants and their visitors and their customers. So you have a parking lot for a shopping center with 5 stores in it. That parking lot is shared by all 5 of those tenants and all of their customers. So it's difficult to point to one tenant and say, you are responsible for the entire parking lot. The tenant would say, that's not fair. I'm paying for the parking lot and other tenants are using it for free.
Right, that makes sense.
Yeah, and so basically those parking lot expenses primarily get rolled into common area maintenance charges for the tenants?
Common area maintenance charges are the cost for the landlord to maintain the common areas of a piece of property, whether it's a parking lot, a sidewalk, a roof. A very common one that people think about is snow removal. Who pays for the snow removal? So all of those costs are thrown into one big bucket of costs, and then they're shared amongst the tenants, usually in the same percentage that the tenant is leasing of the shopping center or the storefront. So if a tenant is leasing 20% of the shopping center, they pay 20% of those common area maintenance charges.
Who controls them? I guess the landlord they can just go out and get whatever snow removal bid they want because they're not paying any of it, right?
That is exactly right, Adam, and that is a risk that a lot of tenants take on when they don't have to take it on. There are certain common area maintenance charges that many landlords will agree to what I refer to as a stopgap on, where there is a maximum amount of increase in those each year. And typically we refer to those in the leasing community as controllable expenses, ones where the landlord has the ability to exert some level of control over them and how much they increase from year to year. But then there's also a category of uncontrollable expenses, and snow removal is one of them. We aren't in control of how much snow comes each winter, so we don't know how often the snow plow has to come out to our shopping center. That all being said, you can sometimes get landlords, not all the time, sometimes to get them to agree to an overall cap, and that avoids the situation of them hiring their best friend to come out and do the snow removal and charge an exorbitant rate for
Exactly.
that.
I was just thinking that. I can hire my fiance to come and clean at $200 an hour.
I don't know if that would be enough.
I mean, I'm going to leave that one alone.
Not in this office.
I shouldn't have said fiance. Yeah, not at this office. That's right.
Is there any potential clause that you seek to have inserted in leases, regarding the overall caps?
Usually I try to focus on one of 2 areas. One area is what is included in the common area maintenance charge. Most landlords just want to say all expenses related to the running and operation of the property. Well, does that mean you need to pay for their trip to a shopping center conference out in Las Vegas? A landlord, of course, would say yes, but the tenant may say, I'm a little concerned about that. So oftentimes we try to do a laundry list of types of things that are permitted expenses. The other approach is I really don't care what you spend your money on, but you're going to start with a fixed dollar amount, usually on a per square foot basis, with a maximum increase per year. And as long as you stay within those parameters, I, as a tenant, don't care what you spend the money on because I have controlled my cost of occupancy in the space.
Is that where you start calling it like a modified double net or whatever?
Usually when I get to that, I just call it a lease.
Okay.
Because continuing to stay with the triple net term gets pretty difficult, but it would be falling into kind of a modified net lease. But I usually at that point am just calling it a lease.
Okay, and then I've seen where people, they lease a space, but then the tenant is the one who has to make the updates to it. Is that kind of something that you see a lot? Seems to me like that's riddled with opportunities for the landlord to win too, right? I mean,
yeah, there's a couple thoughts on that. One is you often pay for what you get. So if you rent a rundown location and you are going to fix it up, the landlord is often going to charge you a lower rent because you are renting someplace that may not be in the best condition, may need a complete gut rehab, and so your rent needs to fit with what you're getting.
Typically reflected as a value lease.
Yeah, you could call it a value lease. But on the other end, if you're renting a space that has been fully built out to your exact specifications with the latest and greatest of everything, you're going to pay a lot more on a per square foot basis. So what I often counsel my tenant clients on is you need to look at all of the buckets of the cost to occupy the space in the same terms, typically on a per square foot basis. So what is the cost of the rent on a per square foot basis? What is the cost of your common area maintenance? What is your cost of taxes? What is your cost of insurance? And lastly, what is the cost of your build out on a per square foot basis? Then you can figure out if your total cost of occupancy fits within your budget as a tenant.
this is why it's so important to get an attorney involved, right? I mean, I know there was a person who was going to rent a space in a building nearby us, and they agreed to do the build out. I think I don't know all the terms, but I think she signed a lease, agreed to do a build out, and then basically found out later that the building needed a lot more work than what she knew or what she budgeted for, but she was still basically committed to doing it, even though it was way more than she thought she was going to have to spend, and kind of stuck in the lease. So if you're going to get yourself in a situation like that, it's important, A, to know it, I suppose, and then B, what would do more due diligence to...
Yeah, it's just like buying anything, whether it's a house, a car, anything you buy, you want, or lease, you want to look at its condition and understand what you're getting. If you're going to buy a used car, you're not just going to buy it based upon its color. You're going to want to look under the hood. You're going to want to take it for a test drive. You know, with leasing a commercial space, you're going to want to inspect it. You may want to have your general contractor come out, or maybe even some specialty contractors come out and look at it to get a feel for the cost of your build-out.
With regards to build-out, how many tenants and landlords are now offering concessions or putting build-out expenses into negotiations of the lease? Are you seeing an increase in that at all, or is it pretty common, uncommon?
It is common. It's very common. But again, you have to think of what I call tenant improvement allowance, an amount of money that the landlord is giving to the tenant to do its build-out, or the landlord is doing the build-out for you. You as the tenant are paying for that either way. You're either going to pay for your build-out out of pocket, or if the landlord does the build-out or provides you with a tenant improvement allowance, you're going to pay for that through a higher rental rate. So again, it goes back to really taking a look at the total cost of occupancy for you and judging whether it's better to have the landlord do it for you or better to do it for yourself. And that really comes to a cost of money question. How much is it going to cost me to borrow this money to do the build out, or how much more is it going to cost me to get it from the landlord with a higher rent?
So you mentioned negotiating the increases over the term of the lease, whether it be with the cap for the CAM charges or just an escalation clause in the lease. What mechanisms do you use when determining a fair rate to increase the lease by per year basis? I've heard of CPI increases and some other
LIBOR,
various forms.
Didn't they use LIBOR?
Yeah, they've used LIBOR before. What do you see commonly in?
Usually it is
leases?
either it's one of two things, but both of the components both of the options have the same base. The actual cost is the starting amount. So if your actual only goes up by $10, we're going to go with actual. So it's usually the lesser of the actual amount of increase or a percentage. And typically I see somewhere between 3 and 5% on large-scale commercial leases, or it is a CPI escalating clause, the Consumer Price Index, which is a similar percentage usually.
Hopefully, right?
Hopefully.
Yeah.
Definitely hopefully for all of our pocketbooks.
Yes.
I actually prefer a fixed percentage just because it makes calculations easier.
Budgeting easier for the business.
Budgeting easier for the tenants.
Let me take a step back because I didn't quite follow what you were talking about there. You're talking about increasing the rent amount or the CAM, or what are you talking about increasing?
Usually that's CAM.
Okay.
So if your common area maintenance is going to go up, you want to
Tie it to something
or provide a cap to that.
Okay, so I had this question written down to ask. I feel like it's like obvious now, right? I was going to ask why people get attorneys involved in commercial leases, but not as much in residential. And it's obvious now, like commercial leases are crazy. There's all these variables and all this stuff. But do you do many residential leases, or
I do some residential leases. It's not as common to have an attorney involved in a residential lease. But that being said, it doesn't hurt to have an attorney involved, mainly so you understand what you are signing. And whether I represent a landlord or tenant, I usually am happy to see another attorney on the other side of the deal, because then I know their client is going to fully understand what they're signing.
Right.
And then everybody's on the same page going forward, and there's not going to be a misunderstanding. So signing a residential lease, while you don't have to have an attorney, it doesn't hurt, just even if you just have questions as to what something means.
Yeah, I mean, pretty much every document that we use says on the top left, this document has legal consequences if you do not understand to consult your attorney. We just don't see people do that as much on the residential side as Matt, you probably do on the commercial side.
Yeah, I mean, it's rare that you see a commercial deal go through without attorney's involvement.
So one of the things I noticed that's also a difference between commercial and residential is that commercial brokers can put liens on the properties that they listed or sold for their commissions.
There are some limited lien rights granted in the Missouri brokerage laws for brokers who do not get paid on commercial transactions. Getting them on a residential transaction is much, much more difficult. And
what's the difference? I mean, for us, we have the same license, so it's just whether it's a commercial type of property. I mean, how did this happen that only commercial brokers can do this?
Honestly, the best answer I can give to you is go talk to Jefferson City, because that is one of those laws that you look at and you just say, why is one being treated different than the other? There was
some sort of political action committee or some sort of driving force.
Some lobbying field.
There very well could have been. There could also be some other reason, but that we go with what the law says, and in this case, the law gives commercial brokers a bit more leeway.
So I wanted to be kind of cheesy and just ask kind of an interesting question. I'm curious and I know you won't give names or anything like that, but what's sort of like the biggest size lease or dollar amount that you've kind of seen?
Well, I think the most complex lease I have seen was for a lease of a shop, a retail shop, to go into a major theme park.
Oh.
To
transition it into a theme park?
No, this was a national retailer, operating its store inside a major theme park.
So I can say, like, as an example, Dairy Queen going into Six Flags or something like that. right? I mean, that's just a weird example. But
That would be the type of example I'm talking about.
Okay.
The lease there was extremely complex because the amusement park, the theme park, needed to control not only what their employees dress and behave like, but also how the employees at the retail operator dressed and behaved like. So if you think of you going to a theme park, everything is very themed the same.
Right.
Yeah, uniform code.
Uniform code. So it's not just that. So that was a pretty major lease to work on.
Yeah, and I assume there's significant liability that would became the biggest issues with something that, aside from matching up to their standards.
Yeah, it was. If you don't live up to our standards, you're out.
Yeah.
that reminds me, one of our friends, Matt, one of our co-friends, had a store that he was opening in the mall, and he was burdened by the mall. The mall made him keep the mall hours, even if it didn't make sense for his business. And the mall made him give a percentage of his revenue, I think, to them as part of the lease. That's
there's a component called what people refer to as percentage rent. So what the percentage rent is that a landlord will receive a percentage of your sales as rent.
That's typically gross too, not net.
Correct. So oftentimes what it is that a landlord will maybe give you a little bit lower than market rent, but ask for percentage rent and kind of become a partner of sorts in your business. And if you succeed, they succeed. And usually what it is that they will receive a percentage of your sales after what is referred to as a break point. So until you make $1 million in sales, the landlord doesn't get a nickel. But then after you get $1 million of sales, then you will share 3% or 5% of your sales with the landlord.
which in the case of a mall, that sounds like that's kind of like replacing CAM, or would they still have CAM?
That would be in addition to CAM.
Oh, okay, all right. Let's go open a mall.
How common are personal guarantees
For the tenant to have to sign.
tenant to have to sign when occupying space for the first time or without certain amount of accreditation or
as representing a landlord, it's a default to ask for personal guarantees unless you're dealing with an extremely well established tenant who has multiple locations. But if you are a first time tenant, signing the personal guarantee is part of the game.
yeah, you can pretty much guarantee you're going to be asked to do it when taking up your first
Be guaranteed you're going to be guaranteeing the lease.
I was curious about that. So if Sprint opens a store, they don't have some guy in Kansas City putting a personal guarantee on
No,
the thing.
if a great example is Starbucks. Nobody personally guarantees a Starbucks lease. Starbucks does not need their leases personally guaranteed, but a small family-owned, first-time family-owned coffee shop probably will have a personal guarantee attached to it, even though Starbucks right across the street doesn't. Just because the Starbucks financials are so strong, the landlord can sign the lease confidently that they're going to get paid their rent.
And especially since there's a Starbucks across the street, that probably will put them out of business.
Yes, yes.
Not to be too dark, but have you seen people landlords have to go after someone for personally?
Yes, I have. And it's a part of the leasing that it's the landlord needs to be able to recoup some of its costs that it has put into the lease. So they do go after the tenant, and if the tenant doesn't have the necessary resources, then they go after any guarantors on the lease.
So typically in residential, we see a very drawn out eviction process. You're talking about going after the tenant. That's obviously after they've vacated the space.
They vacated.
Yeah.
So, and residential eviction is different than commercial. The commercial process is usually a little bit more expedited than is residential. But that being said, a commercial can take quite a long time as well.
Has your lease been fought against in court? And if so, which I'm assuming it has, then do you end up, as an attorney, kind of like changing some of the terms of the lease and strengthening it? And like, just as an example, I know our residential sale contract started out as one page 20 years, 30 years ago, 40 years ago. Now it's 8 pages, right?
Yeah.
So has yours been fought, and do you have to keep adding to it?
It's not even fought. It's just experience. Every time you encounter a unique circumstance, you always have to be reevaluating what you're putting into your leases. And it could be that your lease is perfectly fine without that provision, but you encounter a unique situation, so you do choose to add a provision to your lease to help address that issue in the future.
I don't think this exists right now, but if a landlord was like, I need to hire an attorney to write a lease for me, and one way to measure which attorney they should use, would it be to measure whose lease has been like fought the most and won the most or something?
No, I mean, what I tell people when they're looking for an attorney is, most importantly, you have to find an attorney that you can talk with and be honest with and share all of the facts. It's like going to the doctor. If you can't tell the doctor all the embarrassing and scary stuff, they're not going to be able to help you. An attorney can't help you if you're not going to be able to do that. So first and foremost, finding an attorney you're comfortable to talk with, and that you understand and they understand you, and there's a level of relationship there. The second thing is just experience with what you're doing. Not everybody's going to have experience in the exact line of business you're going into, but an attorney who has experience in doing shopping center leases. There are attorneys who do shopping center leases, but there may be a great attorney who only does warehouse leases. A warehouse lease attorney may not have the same understanding of how to do a shopping center lease, because some things are different. But if a good real estate attorney with broad experience would be able to help with most every lease.
So on that thought, is that why going to a firm like yours that has a bunch of different attorneys that specialize in different things sort of valuable? Because I'm assuming if Matt calls you with the warehouse lease and Quinn's done 20 of those, are you going to go talk to Quinn, or?
Yeah, I mean, that there is a great advantage of having the firm, because you just have that many more years of experience at your disposal. And you're right, Adam. If I encounter a lease that is not something that I typically do, I'll go to one of my partners and talk to them and see if they have experience in it. And most often or not, one of them does have experience in a unique type of lease or other arrangement, whatever it might be. So it is valuable to go to an established firm with experienced attorneys with a broad breadth of experience that they can offer to their clients.
That's kind of a similar business model to what Hermann London's done, to where we have a bunch of different agents from different parts of town who do different types of deals and all that kind of thing.
Absolutely. I mean, whether it be the commercial or the residential or property management, you always see agents coming in with questions on deals, and really tapping that expertise and that knowledge base is essential to succeeding.
So I'm hoping you're gonna be able to share some. Can you share some interesting stories? We've kind of been hitting you up with our technical questions here. I want to hear some. My aunt was a teacher, Aunt Marysy. I mentioned her. She's listening, I'm sure. But whenever I'd see Aunt Marysy, I'd be like, "Tell me about the bad kids, Aunt Marysy." Do you have any kind of weird stories where crazy things have happened? Not to put you on the spot.
Yeah, there's always crazy things that happen in leases. Probably some of the most crazy and bad are tough terms with lawyers, because lawyers find the strangest things interesting.
Yeah,
I think probably one of the ones that was very interesting was we were working on a lease to a property. We didn't end up signing it because when we got a little bit deeper into our due diligence, we found out that the land was landlocked and there was no way to access it via car. If we wanted to use it, we would have to take a helicopter to it every time. So we kind of told the landlord, you need to get us access or we're not going to do it. And the landlord couldn't get us access. So we ended up not leasing the property. And I don't know whatever happened to that property, but
he didn't even give you a rowboat or anything?
I wasn't sure what he was going to do when I told the lawyer I don't think there's road access to this. And the lawyer said, I can't believe that's not true. And sure enough, he came back a few days later and said, you're right. There is no access to this property.
I mean, taking me back to my real estate class days where we talk about things that we'll never use, isn't that the kind of thing where someone has to provide an easement to a landlocked property?
To your question, Adam, yes, there are legal means to force easements to be granted.
You guys didn't want to wait around for that.
We didn't want to wait around for that. And, when you looked at the property, it looked like it had road access, but it didn't.
Were you kind of turned off a little bit that it was misrepresented that way?
Yeah, I mean, it was disappointing that we went down the path so far, and the client had spent money on working on a lease to come to find out that you couldn't access the property. Yeah.
So most of the time I would try to think of situations where it's, generally you would think it's more of a landlord would be neglecting somebody if they're like, my furnace is broke or my roof is leaking or whatever, and the landlord's neglecting. Are there cases where the landlord's kind of too involved and they're coming around too much and they're trying to tell people how to run their businesses and stuff? I mean...
Yeah, I mean, you've got landlords who are, very interested in their tenants' business. Those are sometimes percentage rent landlords who are getting a percentage of the sales. But other landlords just do come around and poke around too much. So it's important for both landlord and tenant in their lease to have some sort of negotiated access rights.
Okay.
Especially for a tenant or a business that is not open to the public. If you're renting a restaurant, the landlord can walk in there and eat lunch whenever they want and look around and see how things are going. But if you are a business that is not open to the public generally,
like financial
services, you may not want the landlord poking around as often. So you want to negotiate in your lease access rights, because it is fair for the landlord to be able to come in and take a look around every once in a while, but they shouldn't disrupt your business.
That's another, I'm just like, another reason to need representation, because you would never think that my landlord's going to be coming in here all the time, but you're like, I've seen it, so we put this paragraph in there.
Yep. Usually what it is 24 hours notice. Yeah. We'll arrange an appointment. You can come by. It gives us opportunity to put anything away that's confidential. Or, just like when your parents would come visit you in college, it gives you an opportunity to clean up your apartment.
When you're selling, say, an investment property and you have tenants in place and you're taking in rent and you don't want to release the financials, a lot of the owners are asking for confidentiality agreements. Mm-hmm. What kind of protection is that affording the owner in, having an executed confidentiality agreement?
Well, in the case of selling a shopping center, it's a great example, where you've got multiple tenants. There's two levels of confidentiality. One is between the tenant and the landlord. So tenants want to make sure that if they're giving financial information to their landlords, that the landlords are keeping it confidential. And then between the landlord and a potential buyer, that there is a confidentiality in place, that if confidential information about a specific tenant or just general financial information about the shopping center is given, it's not going to be advertised to other people, other competitors in the area. So it is good to have a confidentiality agreement signed. The two or three important components of that are, one, just what is the information that's going to be kept confidential. Usually that's just everything that's given. Sometimes it can be a little bit more specific, but that's usually the general definition of anything that's given by the seller to the potential buyer. Another thing is, how long do you have to keep it confidential, or how long is the agreement going to be in place? And usually, some people want those indefinitely. Some people say, after 5 years, my financial information is so out of date, it doesn't matter. But the third thing, and this is the one thing that I always try to make sure is in there, is that if I'm giving the information, I can always, and the deal falls apart, I can ask for it back, or I can ask you to sign a letter saying you've destroyed it all, so that I can then rest easy that I'm not going to have my information shared around with other people.
That's an outstanding point, and I probably executed 24 confidentiality agreements to get financials on properties, and not once have I been asked for that information back. And obviously I've shredded it or, make sure it's not gotten in anybody else's hands. But that's a very valid point that I think a lot of property owners don't understand. So that's pretty impressive. The follow-up I had for that is, in the instance of a breach of that confidentiality, what recourse do you have as a property owner or as a tenant in that instance where your information gets out?
Well, typically the first wave of a breach of a confidentiality agreement is some sort of restraining order type action where you are getting a court to step in and tell this person who's misbehaving to stop. And then the next step is getting them to find out where it's all gone, tracking it all down, or getting similar types of orders against anybody who's received it, saying, you did not receive this with good permission, you need to not use it. Those are very difficult cases, because why should Adam be at fault if you
disclose the information.
Yeah, so it's a difficult thing to do, and some of it is, there's a little bit of trust involved.
Yeah,
because the cost and the effort to enforce them will be difficult, which is again why I like to be able to ask for the information back if the deal starts going away or whatever.
I would think it would be hard to measure the damage, right? Because if I mean, we're just imagining situations now, but if I've given you information and you use it to...
Yeah, your competitors know what you're paying in rent every month.
It's like, how do we measure that? But I've been damaged, but I don't know how much, and I don't know what deals I'm losing out on now or whatever.
Sure, how it's going to affect your business in the short or long term.
Interesting.
I think the other thing of importance that some people their eyes will glaze over when they're reading is the insurance section. And what insurance the tenant is going to carry and what insurance the landlord is going to carry. When it comes to insurance, I always recommend that a tenant have the insurance requirements reviewed by their insurance agent. One, to make sure they can get the insurance, and two, to make sure they can get it at a reasonable cost.
Yeah.
Some landlords are trying to require, and some landlords have very good reasons to require, very high levels of insurance. And a tenant, again, going back to this, how much is it going to cost me to occupy this space, needs to be able to understand what their insurance costs are going to be and what their obligations are. So I think that's another provision that is often quickly read over and not thought carefully about. I think the last one, I think it's also really important, especially in shopping center leases, is an exclusive rights provision. You don't want to invest your life savings into opening a really good sandwich shop only to then 3 months later have Jimmy John's open next door. You don't want that. So when you are leasing in a shopping center, to be able to protect your investment, getting the right to be the only sandwich shop or whatever your business is, to be the only one in that shopping center is important.
We're seeing that a lot with the fitness centers that are popping up all over the place.
They want to be the only fitness center
rights, absolutely.
In the shopping center.
And that the landlord, that only applies to the limit of power or whatever that the landlord has, right? I mean, if my landlord owns this building and a different landlord owns next door, obviously my landlord can't promise me that no realtor office will open next door.
That's exactly right. It's only what your landlord owns. But sometimes your landlord owns more than what you think they do.
Yeah.
So sometimes
I know my landlord does.
Yeah, absolutely.
It's making sure that to the extent you can, getting the landlord to agree that all of its properties within a certain radius of your location are going to be protected by the exclusive use.
Some excellent points there.
Yeah. Any final questions for him? Mr. Hickel, do you want to read do you have our lender has this NMLS number he has to read. Do you have something like that you need to tell?
Again, I just need to say, whoever's listening to this, I'm not your lawyer. I'm just here talking about commercial leases, and if you have a specific question, you should talk to your lawyer or a lawyer of your choosing, and every situation's unique, so it's important to have a lawyer.
Do you mind if we give the phone number for your office?
Certainly. If you want to call me and talk with me, you can reach out to me. It's Doug Hickel. I'm at Summers, Compton, and Wells, and my phone number 314-991-4999.
Unfortunately, I have that number memorized.
That's a good thing, Adam.
Okay, good. Well, I have 5 questions I like to ask every guest.
Okay.
And this is not about commercial leases. Thankfully, I don't ask everybody about that, but just a little bit of kind of getting to know you stuff.
Sure.
The listeners want to know more.
Listeners want to know.
So,
Give them
Doug,
what they want.
some personal questions, I guess.
Sure.
And, I'm sure you know how to plead the fifth or whatever if you don't want to answer. But so Doug, who lives under your roof?
I'm married. I have a lovely wife, and I have 3 children.
Oh, my gosh.
3 children. I have a 9-year-old, and I have twin 5-year-olds.
Oh, my condolences.
How did you have time to be here today?
I love them all.
Yeah.
And then I have a dog.
Okay, good. So where are you your best?
Where am I at my best?
Probably when you're at home and one of them's on your shoulders. And
the best parts of my day are the days when I walk in the house and all the kids come running at me and the dog comes running at me. That's my best part of my days. Best at doing my work is sitting in my office, at my table and chairs. That's where I do my best work. But the best place I like to be is with my family. Okay, good.
Do you have a favorite blog that you read or podcast that you listen to, or if not, maybe a book that you've read?
I for general reading, I typically defer to just the apps on my phone. I read a lot of the BBC News and the CNN News. As for online, same type of thing. It's usually just the major news services.
So you're not really reading like Attorney Today. You're reading just kind of like general news stuff.
But when it does come to reading legal publications, it's usually still good old print material that I read. I get some publications from the Missouri Bar. I get some publications from the Illinois Bar, where I'm licensed in both Missouri and Illinois, and I'm also licensed in the state of Colorado. So I enjoy reading the most recent legal rules on operating ski resorts, and those are always fun to read. Not too practical here in St. Louis, but still fun.
Okay. What is your guilty pleasure?
My guilty pleasure. It is probably reading for pleasure. I read a lot for pleasure.
Okay.
And probably sometimes more than I should.
Did you read the Game of Thrones books?
I have read every Game of Thrones.
Story of Fire and Ice.
Oh my gosh.
You know.
Song
of Fire and Ice. Oh, see, yeah.
Well, we don't have time to talk about that, but I can add another couple hours.
We could do a 2-hour podcast.
Yes, you could read a lot of that.
Okay, Doug, who is your mentor and how have you thanked them?
I would probably say my greatest mentor has been my father. One, just teaching me how to be a good guy, but then also helping me be a lawyer. Having been a lawyer for many, many years, he's got a lot of great wisdom and a lot of great ideas to share with me as I'm, being a lawyer as well. And even though I've been doing it for almost 15 years, I still call him sometimes for his thoughts on stuff. And
so how have you thanked him? Does he know that you're his mentor?
I think he does.
Or he's your mentor?
I thank him all the time for the thoughts and the advice and just being a good dad. So the most recent time was probably on Father's Day.
Yeah, I was going to say, what a fantastic follow-up. Absolutely.
On Father's Day.
Well, Doug, thank you very much for being here. Mr. Simon, thank you also very much for
pleasure.
being here. And if you do have commercial real estate needs, of course, please call our agent sitting right here, Matthew Simon. And Matt, what's your phone number?
It's 314-922-3523.
3523. Okay, I almost had that one memorized too. And we're going to wrap up the podcast. So if you have any questions, you can email them to podcast@hermanlondon.com. And check out our website. We've always got new information going on. Joey, our producer here, has been working on some crazy drone videos. So if you want to see those, go to our company Facebook page or hermanlondon.com as well. And thanks very much for listening, and take care.